seat. We're about ready to get started, all right? No, I'm not trying to scare you away. Come back. We still have room. Good afternoon and welcome, everybody. My name is Judge John M. Pacheco. I retired from the San Bernardino Superior Court about a year and a half ago. I'm honored to be part of the American Board of Trial Advocates, who's going to be presenting this case. And what you're going to see today is a reenactment of a busing case. Dr. Orfield, who's here on behalf of UCLA, who was actually part of the busing case, does not like to call it busing. He says it was an integration. The court mandated integration. We had to go through 28 days of hearings, over 4,000 documents that are maintained at the USC library. And I have to thank a wonderful law student that's from Laverne, Colin Whittington, for getting those documents for us. So that way we could use the presentation. Judge Egly was a champion of justice. He is a man that had the fortitude and the courage to do his job. And you're going to hear about everything that he went through. He had so many threats. He lost friends. And his wife is here today, Jane Egly, and hopefully you get to hear from her. So the case is about integration in the 70s of Los Angeles Unified School District. It was, if not the most controversial case of the 70s, and Judge Paul Egly presided over that. We have some wonderful speakers today. We have from ABOTA, which stands for American Board of Trial Advocates. That's an elite group of trial lawyers. You have to try so many cases just to get admitted to that organization. We have Mr. Brian Reed, if you'll stand up. He's going to, if you'll hold your applause until the end, because we got quite a few people. But he's going to tell you a little bit about why we do the James Otis Lectures. Really good at that. And we have speakers that you're going to see on video. State Senator Alois Gomez-Reyes is going to give you a message, and she's going to talk to you about the importance of the three different branches of government and how they're under attack today, and how they're under attack in a horrible way. She's going to talk to you about why it's so important that we maintain the separate branches of government in order to preserve our democracy. You're going to hear from the Supreme Court Justice of California, Patricia Guerrero, who's going to talk to you about the Constitution, because today is Constitution Day. Then you're going to hear from a very famous professor, Professor Gary Orfield, who actually was part of this whole implementation plan. He was a witness in one of those court hearings, and he had a lot to contribute to Judge Egly when Judge Egly did his decision. Then we're going to do the actual case presentation. Obviously, we can't squeeze in 28 days of hearings. We're going to give you 20 minutes of hearings. Working or representing Crawford is Mr. Bill Shapiro. Will you please stand? Yeah, he's real humble, just so you know. Next year, he will be our National American Board of Trial Advocates president. So he's big deal. And representing the school board is Miss Cynthia Hafif Stonehouse, a very prominent trial lawyer. How many trials do you have under your belt? 100?
At least.
Over 100 trials under her belt. Also a member of the American Board of Trial Advocates. And not the least, we have the immediate past president of California Judges Association, who's going to be acting and playing the role of Judge Paul Egly, The current judge, sitting judge, is Ms. Kim Apollo. So do we have a lineup or what? I've talked too much already, so let's get the show on the road. Brian, come on up.
Well, it was what I can only expect was a very cold winter morning in Boston, Massachusetts in February of 1761, 15 years before, more than 15 years before the Declaration of Independence was signed and announced, when a 37-year-old lawyer named James Otis Jr. Stepped into a courtroom to address what was then the equivalent of the Massachusetts Supreme Court. Of course, these were all justices appointed by the Crown. And he was there to argue against a series of laws called the writs of execution. His argument lasted 5 hours. He introduced concepts that had been unheard of up to that point in time. He talked about these laws, these writs of execution, which allowed the government, allowed the Crown to invade private homes without probable cause, without court supervision, without any notion of a crime having been committed, to search. Attorney James Otis viciously opposed that. He introduced concepts of natural rights of Englishmen. He talked about an unwritten constitution of the Crown and how these rights, the rights of the citizens, should prevent the Crown from being allowed to search without cause and without judicial supervision. In the back of the courtroom sat a young trial lawyer named John Adams. John Adams was transfixed by the argument of James Otis. He tried to write down every word, and after probably several hours, he started to write summaries. But John Adams, years later, he was quoted as saying, he wrote, Otis's arguments were a wake-up call, and he attributed those arguments as the beginning of the revolutionary movement. He said he believed that that day in that courtroom, then and there, the child of independence was born. So the American Board of Trial Advocates presents a James Otis Lecture Series where we introduce concepts of the Constitution in the name of James Otis to high school students like you all, and we're so very, very privileged to have you all here. Today, the Crawford case is a highlight of one of the amendments to the Constitution, the 14th Amendment, Equal Protection Clause. And so we're glad to have you here. It's our privilege to present this to you. It's our privilege to introduce you to an amazing advocate, Mr. James Otis. And I will turn the program back to Mr. Judge, Honorable Judge Pacheco.
Thank you, Brian. So now, ladies and gentlemen, you're going to hear by video first, and I won't get up in between, but you're first going to hear from our State Senator Eloise, and then you're going to hear from our Supreme Court Justice, Patricia Guerrero.
Hi, I'm State Senator Eloise Gomez-Reyes, and I represent the 29th District here in California in the county of San Bernardino. I'd like to speak to you briefly on the importance of the three branches of government, and in particular, the role that the legislative branch plays in our democracy. The three branches of government have been our checks and balances, and these have been in existence for nearly 250 years, designed so that each branch is separate but equal. The three branches are the executive, the legislative, and the judicial. The executive branch nationally is our president. Here at the state level, it would be our governor. The legislative branch nationally would be our U.S. Congress and U.S. Senate. Here at the state level, it would be our state assembly and state senate. The third branch, the judicial branch, is our judges. The highest court here in California is the California Supreme Court, and I'm very excited to know that you will be hearing from California's Supreme Court Chief Justice, Patricia Guerrero, who will talk about the rule of law and our Constitution. She, like the attorneys in this room and myself, took an oath to protect and defend our Constitution against all enemies, foreign and domestic. Now, the legislative branch has a duty to enact laws. This is a process that includes the introduction of bills, which are debated and voted on by both houses of the state legislature. If the bill passes both houses, then it would go to the governor's desk. The governor can either sign it or veto it. If it is signed, it becomes law. These laws on occasion require interpretation, and that is when the judicial branch comes in. They would be tasked with reviewing the opposing views and making a final determination. In the case you will be studying today, Judge Egly refused to be swayed by public and political threats and ruled on desegregation of schools according to the rule of law. He was under attack but stood firm to his oath. The relevance is that we must not be beholden to anyone, nor shall any one branch or be more powerful than the other. Today, our democracy is under attack like never before, and we must resist any efforts to destroy or overthrow our government. There is so much to learn from Judge Egly, and I hope that this will be a good learning experience for all of you. I look forward to hearing results in the near future, but for now, do enjoy. Thank you.
I want to welcome everyone attending today's James Otis Lecture Constitution Day event. I give my thanks to the American Board of Trial Advocates and the Verne College of Law for putting on this lecture and giving me the opportunity to take part in it. I understand today's event will focus on something that is crucial to our system of justice in this country and an issue that I care deeply about, the independence of the judiciary, and more specifically, why judicial independence is so critical to the rule of law and our system of government. As you will learn today, the legacy of Judge Paul Egly highlights not only this critical role of the court, but also the perils faced by individual judges who are often tasked with enforcing constitutional rights, even in the face of unpopular public opinion. Judge Egly's efforts to desegregate public schools in Los Angeles in the late 1970s and early 1980s were deeply unpopular at the time. But his orders were compelled by a 1976 California Supreme Court decision holding that the Los Angeles Unified School District must desegregate its schools in order to protect the constitutional rights of minority children. In taking on the duty to enforce that 1976 court ruling, Judge Egly knew he would have to endure political pressure and public criticism. When asked if this pressure worried him, the judge replied, "Of course it does. I thought about it and swallowed it with a gulp. But I have been a judge for a long time, and a judge's job is to judge." As Judge Egly recognized, when we become a judge, we take an oath to support and defend the Constitution and the laws of our state. In upholding that oath, judges must make decisions according to the law as written and not based on their own personal preferences of how they would have written their own versions of the same laws. Simply put, impartial judges don't promise to support and defend any one person, political party, popular ideology, or even their own preferences, but instead promise to enforce the rule of law. And Judge Egly, in being faithful to that oath, was determined not to have the law be ignored in face of popular opinion, even if that meant his rulings would expose him to death threats, hate mail, and outcries for his removal from the bench. In fact, according to a local journalist, quote, "For a time, the name of the judge who presided over it all became the foulest four-letter word on the civic tongue, Egly." Judge Egly understood the importance of separating individual judges' beliefs from every judge's duty to enforce the law required under the circumstances. To that end, after his tenure on the desegregation case came to a close, Judge Egly declared that the case has been associated too much with the name Egly. It's Egly's plan, Egly's order. People have to understand it's not Egly. It's the courts, it's the law. No matter what judge follows me, he'll have to follow the law, with more luck than I've had, I hope. Judge Egly's emphasis on judicial integrity demonstrates why an independent judiciary remains one of the most powerful safeguards of democracy. It is not simply about protecting judges from politics or ensuring that the law does not bend to the whims of the majority. It's about protecting society's most fundamental promises established by statutes and the Constitution. Equal justice under law, even when those promises are uncomfortable, unpopular, or inconvenient. Thank you all for participating in this Constitution Day event. I hope what you learned today inspires and enlightens you.
That is your Supreme Court Justice of the State of California. She's an amazing, amazing person. I would be remiss if I did not recognize a couple of the dignitaries that are here. We have the current president of Orange County ABOTA, American Board of Trial Advocates. Mr. Juan Delgado is here. Please stand up, Mr. Delgado. We also have the current presiding judge of San Bernardino Superior Court and also an alumni of Verne Law School, Miss Lisa Rogan. So why do we do this reenactment? Why did we do it here? You know why we did it here? Because Judge Egly founded this law school. After he retired or was resigned from the bench, he went on to form Verne Law School. And to this day, to the day of his death, I think Dr. Orfield will tell you, he regretted, he remembers the case vividly because it was always in his mind. Every day he listened and remembered it. But he had a significant impact. If I have already mentioned this, I apologize. I'm at a convention this weekend, and I am telling people, the judges, retired judges, or just a judges convention, I'm telling them, hey, you need to watch this online. It's going to be, you can see it on YouTube. And I told them what was it about. It was about the Crawford case and the busing and things like that. And I had a judge kept raising her hand when I'm trying to do this. And finally I said, yeah, you had a question? And she says, she stands up and she says, I'm the current supervising judge of downtown Los Angeles Superior Court. My name's Tamara Hall, and I owe my judgeship to Judge Egly, because every morning I would get up at 4 in the morning from Inglewood and I would get bused to San Fernando. And at first I thought this was the worst thing that could happen. But she said, you know what? It opened the doors, it opened my vision. I saw so many things, and to this day, that's what allowed me, or made me want to go to law school and made me want to be a judge, like Paul Egly. So now, you're gonna hear from a professor who was around during this days of Crawford. He has so much knowledge. He's a tremendous professor from UCLA. He's been a civil rights professor for over 40 years? Over 40 years. He has... Yeah. Yes, and they know each other from all the years of working together. But I did mention that Judge Jane Egly's here. So you're about ready to hear from Dr. Orfield, all right? Oh, then you can see there he is. There's Paul Egly in the bus. Because he wanted, well, I think Gary can talk.
Well, happy Constitution Day. It's an important day, and there's a tremendous amount of talent in this room. Wish I could tap all of it right now. I'm sure we could solve our condo problem in a minute. But I would like to say, when I was asked to come, I accepted right away because I admired Judge Egly. I got to know him well during the trial. I had a chance to talk to him many times, and over the years, I caught up with him. He appointed me. I first got to know him because he called me up on the phone at the University of Illinois, and he said, Professor, both sides are using your research in this case. Will you come out and help? And I said yes. And I spent much of the summer of 1978 trying to answer a number of the questions the judge had. I also ran a review at UCLA where we brought the participants of the case together several years later to talk about what had happened and produced an article about it. I had conversation with him at his home later on, and we visited him and his wife Jane. And he sent me a copy of a draft book that he had written on the Crawford case because the dean, Donald Dunn, had asked him to do it. So I know about him in a number of ways over the years, and I have strong respect for him. There's a famous book about the judges of the South after the Brown decision called 58 Lonely Men. It was about the trial judges in the federal district courts across the South who had to implement the Brown decision. Their lives were disrupted completely. They had to defy the beliefs of people in their communities. They had to be ostracized and so forth. Some of them did a great job. Others of them just tried to punt the case down the road. But they were at the cutting edge. The Supreme Court didn't actually order any district to do something. It was a federal trial judge. And those judges had their lives changed by it, sometimes for the better, sometimes for the worse. I often think of Paul Egly as a lonely man out here on the West Coast who was isolated and expected to implement an order about an issue that was unpopular here, and who did it with some courage and some determination. I've been involved in more than 36 class action suits across the country, some number of which went to the Supreme Court, most of which were about school or housing desegregation. And I saw many judges in place. Judge Egly was a good judge. He was committed to this issue, and he believed in the goal. And he was an optimist. He thought he could find a way to solve it. Most judges have a heavy docket in many cases, sometimes hundreds of cases in a federal district court, but they tend to remember this particular kind of case because they're making judgment on their whole society, and they're doing something that nobody else really wants to do, and they're trying to tell hard truths about the history of their communities and order difficult changes. Judge Egly was a judge in an outlying suburban area in Pomona. He was not used to handling gigantic class action lawsuits. Unlike most judges, he worked in precedents and testimony. He didn't work in statistics and social sciences and grand studies of great metropolitan areas, but he was put in charge of the second largest school district in the country, and in a critical case. First, he had worked in San Bernardino in a small case involving a few segregated schools, where he had accepted the assignment that no other judge wanted to try to solve it. And he found some good solutions for voluntary methods, and the Supreme Court of California upheld him. So he became famous as a judge who actually got upheld in a school desegregation case. And when the Los Angeles case came up, they were looking around for a judge to handle it. Every single judge in Los Angeles County turned it down. So they turned to Judge Egly and asked him whether he would take it on. And he did take it on. He knew it was an enormous change. Second largest school district in the country. It's also the center of racial change in the country, because Los Angeles was beginning to experience the first vast wave of Latino immigration in American history, and was going through a huge transformation. Los Angeles was the center of the largest black community on the West Coast, which was really slightly larger than the Latino community in the school district at the time, and by far the largest Latino community in the West Coast, which was growing exponentially. He inherited part of what had become a 13-year-old, would become a 13-year case that had been delayed pretty shamelessly by the Court of Appeals 2 times. First, initial decision under Judge Gettleson, and then before the case was assigned to Judge Egly. The case asked for basic change in the city. The evidence of inequality was intense. Judge Egly told me he sat in his courtroom and he listened for day after day, month after month, to testimony about inequalities and discrimination in Los Angeles. And he would go home and watch television, and there would be nothing on television except an anti-busing group demanding that he be removed from the case. He said the people in Los Angeles never learned what he learned, that he had to learn. That's one of the things about judges in civil rights cases. They have to listen to things that nobody ever wants to hear about their own community. The Los Angeles School District, in this case, was bitterly resistant. It hired all of the leading experts against desegregation in the country. It spent a lot of money doing surveys and other things to try to prove that desegregation would fail. And it recommended one of the worst models in the country, the Dallas case, as a remedy. The school district, even though the school system had become majority non-white, was actively hostile throughout the case and never proposed a remedy that was anything like the remedies that had been admitted elsewhere. One of the things that I noticed when I came to work on this case is almost no one in Los Angeles knew what had happened in the South, because the South had desegregated big cities for 20 years before Los Angeles. And I'd been involved in many of them and had visited many of those school systems and schools as a representative of the U.S. Commission on Civil Rights. So I knew what had happened, but almost no one here actually knew that there had been many of the largest metro areas in the South successfully desegregated across the city and the suburban regions, which eventually became the issue here. Judge Egly said 26 years later when he wrote his book that he was deeply sorry that he had not been able to solve the issue. I have been unable to forget my part in that lawsuit, and my regret somehow or another is that I could not make it better. Oftentimes judges and civil rights lawyers, of course, deal with virtually impossible cases or deal with cases where the deck is stacked against them, and certainly this was the case in Judge Egly's experience. Judge Egly was an optimist. He believed that the people of Los Angeles could solve the issue, and he believed that the courts would sustain it. When I first met with him, I said to him, Judge, I've studied these things around the country. This is dragging on so long. In my experience, the longer the case proceeds, the more you'll get the worst elements of your community organized and politicized. He said, no, we'll solve it here. He did everything he could to solve it. He listened to all the parties. He actually went and talked to the mayor. He went and talked to the LA Times editor and tried to get them to say something positive to support the court. They refused. Egly will believe that injustice was triumphing in this case. I had to do a great deal of work looking at the issues that he was curious about. One of the things that, for example, I looked at was, well, how many students would need to be transported to desegregate Los Angeles? 8,000 buses. I called the State Department of Transportation and said, how difficult would that be? And I thought they were going to say we needed an extra lane or something. They said to me, well, we run 5 million vehicles every morning. It wouldn't even be a significant presence. In other words, what people were so afraid of wouldn't even be a decimal point according to our transportation system. He appointed 8 experts. 4 of us were social scientists who looked at the area. One of the things we looked at was the demographics of Los Angeles. All of us saw that it was not a stable city. It was in dramatic transformation. One of the experts that was appointed found that from the time that the first black students entered a school to the time that it was totally resegregated, before busing, was 7 years or less. So that it was a very unstable situation where the black community and Latino communities were expanding and thousands of new all-white suburbs were being built outside of the city. So could it be desegregated inside the city? All of us who were experts looked at it and said, no, it couldn't be. It was already changing so fast. We could predict with confidence that the San Fernando Valley, major parts of it would become minority within a generation. The demographics were already set. One of the issues that we looked at was pairings of school districts. I actually drove out with them and met people at both ends of many of those situations. We looked at housing. Housing is obviously the basic problem in Los Angeles because there was huge non-white populations moving in and huge white suburbs being built. All of Orange County was being converted from farmland into suburbs. One of the issues that the Los Angeles School District used was white flight. There was a lot of white flight, but residential change had been driving it long before school desegregation, and we knew the residential change would continue afterwards. We predicted that it would resegregate no matter what was done about the court order, but people didn't believe it. So the people in the San Fernando Valley sponsored Proposition 1, which put into the state constitution new provisions that made it impossible to use the earlier Supreme Court decisions in California, which were more generous in terms of desegregation policy. But it turned out we were right, they were wrong. Resegregation did take place. It didn't stop for a minute after the court order was dropped. Although the people who were elected to the school board on the bus stop platforms promised that it would. Eventually, there was a modest plan implemented for 1 year that affected mostly the middle schools. Before that, there had been voluntary plans, which Judge Egly thought were unfair, and so did I, mostly called permits with transfer, which allowed black students and Latino students to transfer to suburban districts, like the judge was talking about earlier here. And it was interesting because there's a double consciousness about them. I went down and met in South Central with leaders of the black community in Los Angeles. And it turned out that they criticized this one-way transfer program, but many of them had children on it because it transformed their children's lives. So when Judge Egly took over, there was a plan. They were still letting this Los Angeles School District submit plans, and the plans that were submitted and the one that was implemented was about a crazy system of pairing schools, where schools would try to pair with each other voluntarily, which never was done any other place that I know of. So everybody was trying to pair with Asian schools, for example, which were then counted as minorities. The civil rights movement, of course, had some effect on California. California, in the middle 60s to the early 1970s, actually adopted some positive policies about school integration. But by the 1980s, California had become negative. And there was an all-out attack on the California Supreme Court going on a variety of issues. And the court had become tepid and afraid. Egly believed that if desegregation was going to succeed, it had to be a community effort. This, in my experience, was actually wrong. In the South, almost nobody did it voluntarily. It was ordered. And it was ordered quickly, and when it was ordered quickly and implemented, people settled down and lived with it. And here in California, for a long time, there was a search for a voluntary solution. There was none, but the opponents organized against it. Egly did many things. He studied the record. He tried to generate community support. He appointed a referee to negotiate. And he approved the school district plan eventually. That was a very partial plan. Now, the newspaper in Los Angeles found out that he was discussing a metropolitan plan, because there was a precedent in California in Palo Alto about merging school districts to achieve desegregation. It was obvious to all of us who were experts that that would have to be done for stable integration in Los Angeles for many reasons. One was busing kids from South Central to the San Fernando Valley was much more difficult than busing them into nearby Orange County, and similar issues. There was still a large white majority in the metropolitan area. So Judge Egly was an optimist in the best sense. He believed there were solutions. And of course, there are always solutions, partial solutions, if not total solutions. He believed people would work together to solve problems. He believed the court system would sustain him. He ended up disappointed on each of those dimensions because a valid plan was never submitted, nothing even partially valid. Opponents were allowed to organize outside his court almost every day, and they began to be very active in politics. And of course, they changed the California Constitution with Proposition 1 in 1979. The Court of Appeals was a consistent opponent to this remedy. Judge Egly believed in the California Supreme Court strongly. The California Supreme Court, over the years of this case, starting with the 1972 decision out here in Pasadena, has supported desegregation. When Judge Egly's case came up to the Supreme Court after the passage of Proposition 1, the court refused to take the case. He was shocked and dismayed by that experience. He was deeply disillusioned by the failure of the legal system to support his order. And of course, then the Supreme Court, which had become increasingly conservative during the Reagan administration, sustained the Proposition 1, even on the same day that it overturned a referendum in Washington state that would have prevented Seattle from desegregating its schools. So in terms of Judge Egly's experience, he was a man who believed in the Brown decision. He believed in using judicial power to solve long-term, deep racial problems. He was not supported by the public, which is not unusual in these cases. It was usual. But he was not supported by the court system, and he was attacked by President Nixon. He was attacked by Governor Reagan. He was attacked by Governor Jerry Brown for this decision. And he was left on his own as a lonely man trying to do this. But what he was doing is he was working in an area, the area that Thurgood Marshall worked in, the area that W.E.B. Du Bois worked in, the area that Cesar Chavez and Maldef worked in, which is often losses in the short term for possible victories in the long run. Now, after the case was decided and Judge Egly resigned, it turned out He was right. They were wrong. He believed it needed to be done. It was not done. Things got worse. White flight continued massively. The inequalities deepened. The segregation levels got worse. We now have a situation where the black students and Latino students in Los Angeles, which is still the second biggest school district in the country, are the most intensely segregated. In fact, the whole state of California now has the highest level of segregation of any of the 50 states for Latino students. And the epicenter of that segregation is Los Angeles and the Inland Empire. This is the most segregated part of the country for Latino students in the aftermath of this decision. And nothing has been done positively by the state government about the issue of segregation for the last 50 years. This is what we're dealing with. Judge Egly tried to do his best. He was heartbroken that he was not supported in that effort, but he should be remembered because this is what civil rights advocates do. They do things that aren't about today or tomorrow. They do things that they spend their lives on no matter what because they have to be done. And what I would say to you when you're thinking about his record is, don't just honor him, actually do something. You are in the middle here in the Inland Empire of one of the most important places for Black and Latino families to move out of Los Angeles and to try to find a fair life here. But they're being pretty highly segregated. And those of you who are at the law school should be looking at that and doing something about it. That would be the best way to honor Judge Egly. Thank you very much.
There you hear it from the expert. And now you're going to have the reenactment. So we're going to roll away things and get things ready. And while they're doing those things, I just want to put this case into perspective, as he has and as our Supreme Court Justice has. There was so much animosity going on, not just from the white side, but from the black and brown side too. They didn't want things. They felt good in the barrio. They didn't want to have to go to different schools. But what my point is, there was on both sides, and all Judge Egly was trying to do was trying to implement what he was told to do, and that was to implement an integration plan. To try separate but equal is not constitutional. It's not separate but equal. And that's why he did this and worked so hard. I have a famous mentor of mine. He always told me, John, from every bad thing, a good thing will come out. And I'm like, you know, when bad things happen to you, you don't feel like there's anything could ever happen that's going to be a good thing. But if you look at this case, he may have felt like this was bad for him. But what he did, ladies and gentlemen, will live forever. And that's why we're honoring him. His courage, his strength, and his fortitude not to give up and to do the right thing. So at this point in time, I'm going to start the case, and we have a bailiff that's going to go ahead and start.
All rise. Call the case of Crawford versus the Board of Education of the City of Los Angeles. Now presiding, the Honorable Paul Egly.
Thank you. Everybody, please be seated. Good afternoon, everyone. We are going to get started taking oral arguments in the matter of Crawford versus the Board of Education. I'm going to take appearances, please, first from the plaintiffs and then from defense. Thank you.
Good morning, Your Honor. Cynthia Stonehouse on behalf of the Board of Education of the City of Los Angeles.
Thank you. All right, we're going to start with oral arguments from plaintiff's side first. Please proceed, Mr. Shapiro.
Thank you very much, Your Honor. Ladies and gentlemen, We dealt with historic segregation up to 1963, when we filed this case to make sure that in an effort to make sure we can integrate our schools as they should have been. We filed Crawford versus Board, and Crawford versus Board went through one delay after another, appeals, various things happened, and it wasn't until 1970 when the result came out, when the judge, this court, made a ruling finding in favor of desegregation. And at that time, the court said there has to be a plan put into place that would affirmatively take measures to desegregate, to integrate our schools as they should have been. Well, we went through appeal after appeal after 1970. Year after year went by, and it wasn't until 1976, when the appeals ran out, when our California Supreme Court finally made a ruling, and we thought we're making headway. And the Supreme Court agreed with the trial court that the policies of the Los Angeles Unified School District promoted segregation. And the Supreme Court ordered a plan to be placed and put into place that would be feasible and reasonable to desegregate our schools. That was 1976, Your Honor. You were appointed in this case in 1977 to supervise and to regulate, if you will, to make certain the review of the plan was going to be sound and put in place, and you were to handle any litigation or legal matters that stemmed from it. That was 1977. And what the court did was to what the district did was to submit a plan that proposed voluntary compliance. I'm going to be speaking about voluntary compliance. They wanted, the plan that the board wants was they wanted the parents and the students and the district to voluntarily comply to desegregate on a voluntary basis. Well, years later, here we find ourselves. We're no further along than we were. I want to talk about voluntary compliance. In 1776, our forefathers declared in the Declaration of Independence that all men, women, are created equal. That was in 1776. Well, that wasn't quite effective with the voluntary compliance, because 100 years went by. We had slavery, we had segregation, and in fact, it was proven in that 100 years that all men were not created equal. And it wasn't until Lincoln, President Lincoln, in 1863, put forth the Emancipation Proclamation that did away with slavery, and it was an order. It was essentially an order of our president, and slaves were set free. And everyone thought we'd have equality. Well, how'd that work out on a voluntary basis? It didn't work out too well for another 100 years, because in 1954, Brown versus the board, as this court knows, where it was ordered in that case that separate is not equal, and we all know that. It's shameful that it took a Supreme Court to say that, but they finally did, and we thought, hey, Brown is in effect. Now we'll have integration. We'll have desegregation throughout the land. Voluntary compliance, how'd that work out, Judge? 1954, 1964. We have this case now filed. Still no voluntary compliance. We're no better off than we were with voluntary compliance than we were in 1776. So here we stand. Here we stand in an effort to have something finally done. It's been over 200 years that voluntary compliance has not worked. We need to have a plan that is a real plan. Now, whether it be busing, whether it be redistricting of districts, we have to have something. We have in the last 200 years gone from a horse and buggy, okay, to speeding automobiles. We've gone from carrier pigeons, okay, to sophisticated phones. We can desegregate our schools with a reasonable plan, with the reasonable minds that we have of people. We have the sharpest people in the world in this country. Let's put it to use. Just like, and I'm not saying it has to be permanent, just like a gas engine sometimes needs to be primed. And once you prime it, it starts, then the fuel flows. And in this case, once we desegregate with affirmative actions, real actions, it will flow. The district will be better, the country will be better. Thank you.
Thank you, counsel. And for the defendants.
Thank you, Your Honor. On behalf of the Board of Education of the City of Los Angeles, we disagree with the argument that has just been presented by the petitioner. The board has made a plan, and that plan is reasonable and feasible to eliminate segregation in the schools in accordance with the constitutional requirements. The plan follows the constitutional objectives. It's not about simply mixing the numbers of the races to satisfy some statistic or political agenda, but rather is to eliminate the harm to the minority students. Period. That's what we're here for. The board's plan has done just that. It has 13 components, and of those 13 different components, it didn't just come out overnight and somehow become generated. Years and years and years of research, national research, expert involvement, educational scholars were involved, community hearings, as well as school districts across the United States that were involved in this. The plan entails permits with transportation, which means open enrollment for the students, busing transfers to allow them to go to different districts and incorporate the different curriculums, integrated curriculums as well. Whether they stay in their district, at least the curriculums would be updated so that all of the students could be educated with the same type of content. Magnet schools, where the students could go to a school that's out of district and participate. Let's say if they wanted to engage in a violin course, they could do that in a different district. Student-to-student options were also part of this plan, where the students would have their voice. They could join clubs, inter-district, outside of the district clubs, talk about what they want to do, how they want to interact, pairing of the grades, pairing of the schools. We've proposed boundary changes, expand the boundaries, contract the boundaries. That way we can integrate different races, all different walks of life, so they all could participate equally in this education. Staff development, education for the staff, integration of staff, bilingual staff, bilingual recruitment. It allows for teaching and the education to be equal and for students to be represented in sufficient numbers so that they can have equal opportunity to education. And of course, we can't forget community networking. Got to have the community involved. Groups, parents, organizations, local TV station. Have everybody work together as a community to accomplish what this plan is intended to do and what we all want it to do, which is provide equal opportunity to education. But unfortunately, this plan doesn't go without some serious consequences. Costs, the number one problem that we have is the district's hands are tied. For 1 year alone, 1977 to 1978, it's going to cost $33 million to implement this plan, and that doesn't even scratch the surface. There's still a lot of areas that need to be covered. LA is the second largest public school in the United States. The student enrollment is analogous to the city of San Francisco. It's huge. The transportation segment alone, we need a lot more. We need monitors on these buses. We need bilingual instruction. We need emergency transportation if a child's too far away from home. After-school funding, food. What about food? The kids are going to be there late days. The other issue and concern that we have, this is not necessarily something that's wanted. You have the government now dictating where these families should be sending their children. Should the government really be doing this? You're mandating 5-year-olds to go on buses for an hour one way and then another hour back. That is absolutely terrifying to a child, not to mention the family, the parents. The parents are going to be told by the government that they can't walk their child into school in the mornings. They're afraid, they're scared. And what type of psychological effects is that ultimately going to have on these children? This court knows. The court has all the statistics. All the psychologists have presented their paperwork to show that the effects are absolutely devastating and lifelong. Not to mention it's unsafe. You're busing these children into environments that lead to violence, social unrest, intimidation, ridicule. Nowhere to go. They're there. How are they going to get home? Their parents could be hours away. You're simply taking away the right to choose. The California Constitution, or the Constitution, it doesn't require that all races attend the same schools. And in fact, this desegregation plan is not going to accomplish what this court hopes or wants it to accomplish. Yes, we all want and we all hope for desegregation. But when you mandate something like this, it's not going to work out. It's called de facto. De facto separation is by fact. People live in certain communities and they live there because they want to live there. And they're segregated because they want to be segregated with people of their own that they can relate to. So are we now going to require people to relocate and move? Are we going to uproot them out of their communities, which is what this court is trying to do? Unfortunately, mandating something like this is going to have a reverse effect. You bus them in, community jumps ship, and they jump out. And we're back to square one with segregation. Is the board now going to be required to resegregate every time people segregate? In fact, 93 of the 264 segregated elementary schools can't even be included in this plan because the districts are too far out and they're too remote. In some, a permanent crosstown reassignment is simply not going to work. To be effective, it has to be voluntary and allow the parents and the students to choose where they want to go, which is we respectfully request this court to adopt the district's plan accordingly. Thank you, Your Honor.
Thank you, Ms. House. You've got 1 minute, counsel. Just one.
We've heard the same thing over and over and over for 16 years. The bottom line is to effectuate integration, there has to be change. And what counsel's suggesting here is we just want to keep things kind of the same. We want to keep it kind of the same. It's going to cost a lot of money. Your Honor, we can't afford not to do this as a society. We have to do what we have to do. You're going to put teeth into the law. We have the 1964 Civil Rights Act. we have all the things I've talked about in history. Voluntary compliance has never worked. Once we prime the fuel, once we get the engine started, it's going to take off. Thank you very much, Your Honor.
Thank you both. Thank you. Well, now it's time for me to give my ruling in this case. The court has considered all the evidence that has been presented over the past several days, and I've listened to the arguments of counsel. And after considering everything that has been presented, the court makes the following findings and orders. That is the duty of the school district board to desegregate its minority segregated schools. Desegregation consists of more than simply providing some minority students with integrated school experiences. It requires integrating schools. The school district board has presented an all-voluntary plan, which does not meet the mandate this court issued in 1970, the judgment of the California Supreme Court in 1976, or the minute orders that this court issued 3 years ago in 1977 to assist the school district in meeting its obligations. First, the all-voluntary plan is not designed to desegregate any of the minority schools of the Los Angeles Unified School District. Second, it treats minority children with less concern than other children in the district. Third, it relies entirely on voluntary compliance with the mandatory requirement, which has proven neither realistic nor reasonable. And finally, its provisions, in light of the board's activities, do not demonstrate the board's commitment, even given more time, to produce meaningful progress in desegregating and integrating its schools. Since March 1977, this court has had the duty to oversee the school board as it completes the desegregation requirement. This court restrained its activities to either granting or denying requests made by the school board about how it will desegregate. This was consistent with the court's perception of the law in this area, and the court felt compelled to be restrained because desegregation efforts affecting large numbers of people should be planned and implemented by the school board, which is elected by the people. This political process should be a responsive instrument to produce mandated community change, and if followed in good faith, should promise longer-lasting success than a plan imposed by a court, which seeks a quicker and more efficient process. However, the test of the court's continued restraint is met by the school board's demonstrated commitment to the need to immediately institute reasonable and feasible steps to accomplish the goal of integrating its schools and to produce meaningful progress in reaching it. The record here shows that the board does not have a course of action designed to meet these goals. Because of that, this court is left with no alternative but to intervene to protect the constitutional rights of minority children. When a local school board continually fails in its constitutional task, a court is no longer justified in relying upon the school board to implement programs which hold a reasonable promise for securing the rights of minority children. To comply with this order and the California Supreme Court's order, the board should and will be ordered to prepare and implement a desegregation plan that meets these stated goals. This is the order of the court. The prevailing party shall prepare the judgment in this matter. Thank you all who have participated here and observed today. Court is adjourned.
Please be seated. So there you have it. I know we had to put 20 minutes of arguments, well, 28 days of arguments into 20 minutes, but we got the highlights for you, and I hope it rang a bell. I'm going to open this up to questions, and hopefully we can give you some answers. But I want to tell you, you students, you're our future. So you need to protect your country. You need to protect your Constitution. Because if you don't have that, you're going to have complete chaos. So you are our future, and I hope you take your job seriously. So thank you. Now, I'd like to open it up for questions. Any questions? Please. Mr. Juan Delgado, you have to have a question. You always have questions.
I grew up in East LA, Royal Heights, when all these cases were being decided. And I was listening to Ms. Half's arguments, and I remember thinking, my mom would say, well, they just want to keep us here, which was a barrio, of course. And I never made it all. I was in the 6th grade when we moved out of there, but I would have been one of those buses, one of those kids' bus. And what I want to ask is, was there any thought of reaching out to any of those kids, other than the judge you mentioned, Your Honor?
I think Dr. Orfil can answer that question.
I haven't done this in a systematic way. It would be an interesting project for one of your classes here to do a survey. I'm sure that it would be easy to track down some of those kids. My wife, who's a Latina, grew up far from the elite schools, but she actually went to school in the Palisades. And she was taken to visit a university. Eventually, she became a very highly rated professor at UCLA. You know, a lot of people's lives were changed by these experiences in the brief time that they were implemented. Where I was seriously involved with the court that actually did implement its decrees in St. Louis, we managed to integrate all of the suburbs, and the graduation rate of the black students who went on those transfers doubled, and the college-going rate soared. You know, it makes a difference if you go to schools where there's competition, where there's experienced teachers, where there's a rich curriculum, go to schools that have connections to colleges. All of those things matter. They change people's lives. And right now in California, you are about 10 times as likely to be in a school that really prepares you for college if you're white or Asian than if you're Latino or black. It's because nothing is being done about these issues. Our suburbs are going through huge racial change, and nobody's working on helping them integrate and remain stable. This change is being allowed to happen, and there's efforts to protect the whites and Asians who live there and to rezone or create exam schools that are very selective, or to build more charter schools. You can't really come up with a successful, lasting interracial experience without deciding to do it, facing the obstacles, making a plan, and implementing it. That's what we have never done here in California for a long time. I've worked in many places that actually did it, mostly in the South. And a very different outcome for those communities.
For the plaintiffs, were you guys representing like a group of students, or who, like the Brown case?
The case was brought on by the ACLU as a group of students. It was almost like a class, and and these around the country. And as Professor mentioned, they've been filed in that nature. We do select one of the class members, if you will, which was Crawford. So that's why the case is entitled that. But it was on behalf of the students of LA Unified. I have a question. I don't know how easy it's going to be for you guys as students to answer it. I grew up down the street in Ontario, California. I went to elementary school here, I went to junior high school, and I went to high school here, and I started my college here. For me, when I went to school in the 60s, it was very integrated, because I went to school with a lot of Latino blacks. I was it was in the middle. It was heavy. How do you guys feel today as students about this topic that we're talking about of segregation and integration? Do you feel we need more work to do? Here, we talked as though we were in 1980. That was today. Here we are in 2025, talking to a group of students. And the concept, the question initially was by Juan, did you guys ever talk to students? I'm talking to students. Anybody have anything you want to share? You feel like can I see a showing of hands of people who believe maybe it's still not fair? Anyone still feel that it's not fair as to the segregation? We have Ms. Egly. Yeah. It's a tough thing for you guys to address, but I think what's important, my point would be, is it's important here at this late date. You know, I referenced the Civil Rights Act, excuse me, of '64. Well, here we are, all these years later. It's still a hot topic. And we hope that you guys at the American Board of Trial Advocates, we hope that you guys have all come to appreciate that we appreciate it. And that's why we wanted to have this program. John?
Or say, we have 3 minutes for questions. Any other questions?
Yes, I have.
Yes.
If I could ask the professor,
Hold on.
Thank you. Professor, as I remember, the argument was, we don't have to drive people all around. Spend the same money on each student, and that's how you get equality. How did you answer that?
It's an interesting question. If you take a community college and some billionaire gives it a lot of money, will it be like an Ivy League school? No, because the school, Ivy League school, or a great University of California school, is the faculty and the students who are remarkable, and the curriculum and its relationships and its role in the community. I've taught at Princeton and Harvard. I've taught at Chicago and UCLA. These schools have assets that have been accumulated over a century. Money will not make another building into one of those schools. It's a huge difference in every dimension of life. The money is important, but the most important things are teachers and other students. So if you're in a school where all of the students are well prepared, you learn a lot from each other. And the level of teaching and the level of competition is much higher. If you're in a school that has experienced teachers who are experts, you're going to learn a lot more than if you are in a school that has new teachers that aren't experienced. There's a systematic relationship between race and all of these things in California. There's fewer experienced teachers, there's more limited curriculum, there's less college-oriented courses. The courses are taught at different levels. It all means that no matter how smart you are, you're not going to have an equal chance in many of these high poverty, isolated, segregated schools as in an integrated school where the expectation in the whole school is structured to prepare everybody for college, and the colleges know it.
We have one last question.
Good afternoon. You know, when I think back to the time frame that you all are speaking to, I would have been one of those children being bused. However, I lived in the Midwest, so I was not. But what I do remember from the Midwest is that when I was born and raised and went to school in Chicago, I went to an all-black school. There were no white students whatsoever. When my parents moved, when I went into the 6th grade, I went to then an integrated school in Southern Illinois, which was a difference. It looked different. How my parents prepped me was different. Things that they said to me, things that we did were different. But it prepared me to be ready to be a part of an integrated environment. And it was amazing. I enjoyed school. I loved it. I loved it more than anything at that point because it was quite the experience going in Chicago. However, my question to the court is once the order was placed, what was the implementation time that it took to get it implemented within the environment? And then what did the environment look like? Was there a certain chain of events that occurred as a result? Was there acceptance? You know, was it fighting constantly, badgering between the parents, the students? What did the environment look like?
That is a loaded 3-hour question. But I think Dr. Orfield will address it in a minute or less.
Wow, that's quite a challenge. Basically, the experience in integrated schools usually is that it's difficult at the beginning, and that things calm down and it becomes normal, and that people actually like it in the longer run if it's stable, if it's well done, and that matters. What happens typically, when I was working at the U.S. Commission on Civil Rights, I visited 10 school districts all over the country that were just beginning to implement the so-called busing plans, the integration plans. I went into the classrooms. I had the right to ask any teacher any question. I told the administrators to stay away. I interviewed the PTAs. And what I learned from that was, for the students, it wasn't a problem. They didn't know why they were supposed to be upset, especially the little kids. It was natural. The teachers all said to me, "It's the damn parents." It's the damn parents that are making these kids so upset. And I believe that that's the truth. And the parents over time settle down. In the first major busing case in the country was in Charlotte, North Carolina, where the Supreme Court allowed big urban desegregation of city and suburbs in a district of 450 square miles. That district was forced to go through this change. Well, after time, the judge released them. They kept the plan. They were sued by conservatives to get rid of the plan. They spent $1 million of school board money, but the conservative Supreme Court turned them down and forced them to resegregate. You know, in many of these places, the desegregation actually worked. In others, where it was put together badly or where you didn't end up with a stable population, it didn't work. It depends on how you do it, like everything else that's important in life.
All right. Yes? We're over time.
Academy, and we'd like to thank you for inviting us here. We are a very unique school, and I don't know where we fit on this continuum and this discussion because we are a magnet school, and we have a long waiting list to get into our school for Ontario. I, like you, went to Chafee and then Etiwanda, and it was very integrated at that time. I cannot say that at this moment, but I had my son who went to Ontario Montclair School District. I was his teacher too, who were Catholics. So he wanted to go to Damien, and he went to Damien, and there is a difference. And he went there 3 years, but then he said, "You know what, Dad? I want to go back to my community school." And he went to Chafee. He got into Berkeley, UCLA, Pomona College, all these schools, because of the teachers at Chafee and at Damien. And at our school, it's more integrated than the other language schools, but it is because we have great teachers, and our school district you should be proud of our school district because you went there, and it's really good. And this is a complex question, and I felt as a 5th grade kindergarten student, my mom, she probably wouldn't have let me bus an hour away and back. So how did you combat that? That is, to me, it's just the cultural pushback that you must have had to try to do this. It's just tremendous.
It was very difficult. 85,000 students were bused during that time. So that was a lot. And you've heard from, like I spoke about, Tamara Hall, the judge, who said it made a life-changing difference. But we are ready for lunch. We're going to go downstairs. It's known. 1 second about this busing issue. We have, okay.
An interesting thing is that kids like to be bused. Most American kids are bused to school. Almost all the kids in outlying suburbs are bused to school, and it's normal. And the surveys of kids who are actually go on buses to schools, nobody goes for desegregation purposes now, is that they like the experience in the morning of talking to each other. My kids were bused to the Booker T. Washington School in Champaign, Illinois when they were young. They liked it. It was not a psychological drain, and that's what the research shows. Busing itself isn't a problem. As Jesse Jackson said, it's not the bus, it's us.
Amen. All right. So we're going to go downstairs to the fishbowl. It's called the fishbowl, and we're going to have lunch, and we're going to have some phenomenal speakers you're going to hear from down there. We're going to be issuing some awards, so lunch is ready. Again, thank you very much. We'll see you downstairs. Dismissed.